Happy holidays, everyone, and thanks for joining our launch party today of Off the Record with Leah. What we're going to be covering today is the motion filed by Duane Keith Anderson in his case, the state of Nevada versus Duane Anderson, aka Keefe D. I promise I can talk. He has been charged in the 1996 murder of Tupac Shakur. Sorry, we are professionals, really. Um, so today we're going to dive into a motion his public defender filed on December 14th, asking that Davis be released on his own recognizance. And again, I can't pronounce that word, so it's probably going to be OR'd for the rest of this stream. Want to thank you for joining us for our launch party. Let me know where everybody's coming in from, and if you don't mind, do the YouTube thing and like and subscribe. I promise you my public speaking will get better. So what's everybody doing for the holidays? Are we traveling, staying home? How many, like me, have to do some last minute shopping and baking this evening? I have 8 grandchildren who are expecting lots and lots of treats. So we're going to be doing that this afternoon, but I wanted to join here today to go through this motion. But first, let's chat a little bit if you don't mind. Also, for the replay folks, thanks again for watching. Like, subscribe. Hopefully, you can catch a live at some point. If not, you are very much appreciated. Real quick, I have filed a media request into the Davis matter, so hopefully we will have access to the pool camera on the January 2nd hearing. So are we ready to dive in? So let's go with some background to start with. First, in the past 2.5 decades, multiple documentaries, books, interviews, and articles have been published detailing the murder of Tupac Shakur. Many provided long lists of suspects. Others, even law enforcement, had an idea. They knew who committed the murder, but lacked the evidence to make an arrest until September 29th, 2023. The reason that I launched early this channel instead of the first week of February as initially planned was because of the December 14th motion that was filed into the case. So we're going to go through that motion in a little bit, but I wanted to kind of give some background and history. 27 years for a crime to be solved is a long time, and there's a lot to parse through. So let's see. Sorry, I do have to refer to my notes because this was again planned about a month and a half, 2 months before we had initially planned to go live. So, sorry. Let's scroll through these. I am a professional. I'm going to need one of those that says that, huh? Actually, I'm a paralegal, so I'm allowed to not be perfect. As a paralegal, oftentimes the attorneys I work for and the judges that we have cases in front of expect me to know as much, if not more, than the attorneys I'm working for. What that really means is I by no means know more than they do, nor do I have all the answers to the questions. What it means as a paralegal is I simply know where to find those answers. So if you have any questions, feel free to put them in the chat and I will do my best to answer them. If not, we'll dig for the answer till we find it. So what led to the murder of Tupac actually occurred in Lakewood, California in July of 1996. It was an incident at a Foot Locker in the Lakewood Center Mall involving Orlando Baby Lane Anderson and a group of the Southside Crips and rival gang members, and I may pronounce this wrong, so I apologize, Mob Pyru, including Trayvon Trey Lane. During the altercation, it is alleged that Anderson snatched a chain from Lane. Doing my research, I found out and didn't know ahead of time that when you remove chains from another gang member or rival gang member, it's considered a great insult. Needless to say, this altercation just provided more flame to the fire that was stoked the aggressions between the two rival gangs. So neither side had forgot the incident. Then on September 7th, 1996, sorry, what happened was Anderson and Lane, as well as others, including Tupac and Marion Suge Knight, probably refer to him as Suge for the rest of the stream if that's okay. We're all in Las Vegas for the heavyweight championship fight between Mike Tyson and Bruce Seldon. What so I've got that. Okay. So in 1996, the gangs and the hip hop music industry kind of intertwined each other, and the East Coast West Coast battle was raging. Davis, in his 2019 memoir, Compton Street Legend, interesting read or listen to, I listened to it on Audible, details how and why what unfolded that night in September occurred. I also want to note that Tupac at no time was ever a gang member. I believe that he just became involved with the members and the lifestyle because he was a member of Knight's Death Row Labor Records, but that's just my opinion. It's not written in stone or fact. After all, I'm just a paralegal. That's We'll get into that later. So the offense, what occurred after the fight really overshadowed the fight itself, which was historic all on its own. It was one of the shortest boxing matches in championship history. Tyson won that fight in a mere minute 49 seconds. There was controversy immediately following the fight, as many in the crowd believed that Sheldon, sorry, had actually thrown the fight to set up a Holyfield Tyson match. For what it's worth, Sheldon denies throwing the fight, saying at the time he didn't train for 12 weeks just to intentionally take a dive. I can't imagine anybody in the boxing world intentionally taking a dive in such a monumental fight, but I guess it does occur. But what happened again after the fight ripped that from the headlines. And unless you are a sports fan like my husband is, there's little to be known about the historic nature of the fight itself. So after the fight, Tupac and Knight and an entourage that included Lane were leaving, and they spotted Anderson alone by a bank of elevators in the lobby of the MGM. Tupac, Knight, and the others confronted Anderson about the stealing of the chain, and a fight ensued. The video surveillance, which can be found all over the internet, let me know if you'd like me to share it here with you as well. What Tupac drops Anderson, I believe it is. Yes. Knocks Anderson to the ground with a punch to the face. The entourage then participated in continuing the assault until security finally broke it up. Now, I don't know what the protocols here in Las Vegas were in 1996, but if that was to ensue today, I guarantee you arrest would be made, and the fact that they were celebrities wouldn't matter. Maybe it's gotten more strict since the 1 October shooting here, but I don't remember even prior to that where a fight of this magnitude could occur in a strip hotel and not some kind of arrests being made. But here they simply got escorted out of the hotel by the security staff, which is interesting to me. So after they were escorted out, Knight and Tupac left in a 1996 BMW 750 IL, pretty neat car, followed by approximately 10 other vehicles. They had a very large entourage. They were headed to Knight's Club 662 here in Las Vegas, doesn't exist anymore, but back in the day it did, and Tupac was supposed to perform there. I'm gonna date myself, but I remember that, and I had so wanted to go see Tupac play live. Unfortunately, events occurred that didn't make that possible. But anyway, Anderson and Davis also left the MGM. They had met back up. Davis has admitted to his in his memoir that he was angry and upset at those, including Tupac and Knight, for attacking his nephew, Anderson. Davis alleges he wanted to seek out Knight to ask him why he and others had attacked his nephew, since he had just seen Knight the evening before and nothing was said. It's also further should be noted that Knight and Davis were childhood friends. They grew up playing football together. So that's an undisputed fact that they did, in fact, know each other and were childhood friends. The rest of Davis's claims are kind of based on Davis's own words. So that's the only thing we can take from it is what he has said, since he is the only surviving person, according to him, it was in the vehicle that the shots were fired from. And now, keep in mind, initially he says in his memoir he just wanted to talk to Knight to find out what had occurred. But in other interviews and even in his memoir, he's admitted to obtaining the gun that was used in the murder, and alleges that it was Sean Diddy Combs who ordered a hit on Knight and Tupac with a bounty of $500,000 each. Combs, of course, has cannot talk. Knight has, of course, denied these claims. It should be noted that Davis has stated he never received the $500,000 for being a participant in the murder itself. So those was he going to kill Tupac and Knight, or was he going to talk, since the two really kind of counter each other? And sadly, only Davis can tell us what his true intentions were for that night. Either he wanted to talk to Knight or he planned to kill him. Only he knows for certain, and whether or not he'll ever share that information beyond what he already has is unknown. So, per Davis's account, and some of which has been substantiated by law enforcement, what I'm sorry. Let's try that one again. Per Davis's account, some of which law enforcement has substantiated. We're going to go through that and kind of detail it when we go through the court case, since it does become relevant. Davis and his group went to Club 662, and they waited outside for Knight and Tupac to exit. However, after approximately an hour, they grew tired of waiting, and per Davis, it was interfering with the real reason they had come to Las Vegas, which was to party and have fun. So what Davis says is after that, they had stopped at a liquor barn close to the Las Vegas Strip, a liquor barn that I myself have been in many times. However, I don't tend to go to liquor stores or other stores or even Las Vegas Strip hotels to purchase alcohol or any other items, because they are substantially more expensive. What us locals refer to them as is tourist pricing. And excuse me while I hydrate, everybody else hydrate, and it's caffeine. And yes, I am a law nerd. So thanks, Emily. I had planned to change cups and forgot to. So that particular cup that says law nerd came from the Emily D. Baker merch store. She has an amazing channel here, and her merch is spectacular. I think I have all of her coffee cups and a lot of her sweatshirts, and that is my favorite travel mug. But anyway, back to Las Vegas. Just a hint, if you're planning to visit us here, the Strip is more expensive, as is everything surrounding it, including the gas stations. And with gas prices the way they are today, when you add in tourist pricing, it can get rather pricey. These prices actually usually go up when there's events, big events like a hockey game, football game, big concerts, etc. I'm interested to see what the pricing does when the Super Bowl comes here this year. Regarding the Super Bowl, go Chiefs. Yes, I'm a Kansas City fan, and for anybody who I know and love. I would never ask my followers here if they go to the Super Bowl. I would love tickets. Hint, hint, hint. All right, back to our prices here. So if you're visiting, I would suggest going off the strip and a little bit away into places to purchase items like alcohol, snacks, etc. Even a bottle of water in one of the hotels and casinos can cost up to $10 or more. Alcohol goes even higher. Also, hotel pricing. Obviously, if there's an event, they go up, but strip hotels on the weekend are also a little more expensive. So, if you're looking for something a little less expensive, again, go off the strip. Fremont Street has some great hotels, and it's a very interesting place. In fact, it's one of my favorites. I, like many locals here, try to avoid the strip, but I will go down to Fremont Street Experience just to people watch. They have street performers that are just amazing and some that are a little odd, but it's still fun to visit. If you're looking to go even less expensive than that, go further off the strip into the area local hotels and you're going to save a little bit of money there. Uber, unless there's a big event, Uber, Lyft, ride shares, etc., aren't too pricey. There's always a cab. There's ways to get around in this town that make it relatively easy. They say our public transportation system is good. I have to admit, I've never ridden the public buses here in Las Vegas, so I don't know. I have taken the shuttles to like the hockey games, and that's convenient if you don't want to pay for parking, which can be outrageous. But I digress. Let's go back to Tupac. I apologize. So, according to Davis, after they left the liquor stores when they spotted the BMW, in part because Tupac was hanging out the passenger side window, talking to fans, flirting with girls, and some of the fans on the street were screaming Tupac. As a result, they immediately turned their Cadillac they were driving in around. And what we know for a fact next is at approximately 11:15 p.m., the Cadillac in which Davis says he was a passenger in pulled up to the right side of the BMW that was stopped at a red light at the intersection of East Flamingo Road and Koval Lane, sorry, an intersection that many of us have traveled. If you're visiting Las Vegas, there is a very good chance that you're going to travel that intersection as well. But at the light, multiple shots were fired from the Cadillac, striking Knight and Tupac. Knight was hit in the head. Tupac was hit multiple times. Despite his injuries and the fact that during the shooting, the BMW obtained a flat tire, Knight was able to drive approximately a mile before being stopped at Las Vegas Boulevard and Harmon Avenue, and also an intersection that if you visit Las Vegas, chances are pretty good you're going to go through. Tupac and Knight were subsequently taken and transported to UMC Hospital, one of our biggest trauma units here in the city. Now, according to Davis, it was Tupac who pulled out a gun first. Davis has alleged that Anderson, who was in the backseat, fired the fatal shots. Law enforcement has also believed for several years that it was Anderson that was the shooter. Unfortunately, Anderson was killed on May 29th, 1998, in an unrelated gang shootout. Prior to his death, Anderson told the Los Angeles Times in September 1997 that he was a fan of Tupac's and his music and denied being the shooter. Terrence Brown, who was the driver of the vehicle, according to Davis, has also been killed in an unrelated incident. Knight, however, did survive his injuries. Unfortunately, however, 6 days later, on September 13th, 1996, Tupac's mother made the difficult decision to end medical treatment and cease life support. And as a result, Tupac was pronounced deceased at 4:03 p.m. His body was then transported to our coroner's office. I have done some volunteer work with law enforcement and our coroner here in Las Vegas. And I have, when you're training, they give you a tour of the office. So I have stood in the room where, unfortunately, sadly, Tupac's autopsy was conducted, as well as It's kind of a room where any high-profile cases that the coroner is involved in, where those victims go. So there were numerous witnesses to the shooting, but none willing to name the murderer until Davis did. There's, again, several claims of others involved, but Knight even continues to be unwilling to name the shooter. At the time, he told law enforcement he didn't see who the shooter was, so he just didn't know. Then in a 1997 interview with ABC Primetime Live, Knight stated he didn't know who shot Shakur, but even if he did, he wouldn't tell law enforcement. Knight himself is currently serving a 28-year prison sentence for the manslaughter of Terry Clark, who he killed in a hit-and-run incident on or near the set of Straight Outta Compton on January 29, 2015. Knight continues to not publicly identify who the killer was. However, interesting, 21 years after the murder, allegedly, I've not been able to confirm it, a formal affidavit was signed by Knight's attorney, Thaddeus Culpepper, in which the attorney wrote allegedly that Knight has known for years that Reggie White Jr. and his ex-wife, Sharita, were behind the murder of Tupac and his attempted murder. So again, haven't done a deep dive on that, so I'll have to go into it a little deeper, and I will let you know what I find. So this does play in again to Davis's motion for the OR, which we'll get into. Davis himself over the years has given multiple interviews. For example, in 1998, with an interview with BET Network, Davis admitted to being the front passenger in the Cadillac and that the shooter fired the shots from the back seat. When asked at the time who fired the shots, Davis declined to name them, stating, and I quote, "going to keep it for the code of the street." Then fast forward to 2009, still no arrests have been made, but the investigation is still going on. Davis was the subject of an investigation into a PCP case. At the time, Davis gave what's called a pro offer. A pro offer is usually made by a person who's the subject of a criminal investigation in exchange for something. In Davis's case, Davis agreed to tell investigators what he knew about the involvement of the Tupac murder, and I believe Biggie, but I could be wrong there. In exchange, LA investigators agreed not to use his statements against him regarding the murder of Tupac. Now, in 2011, one of the investigators, Greg Kading, I believe is how his name's pronounced, stated in his book that Davis told investigators that it was his nephew, Orlando Baby Lane Anderson, who shot Tupac, and that if he had drove up to the left side of the vehicle, said that if he had drove up on my side, I would have popped them. Davis, according to the author of the 2011 book, allegedly stated, "Man, I ain't ever told that to anybody before." So it's my guess that Davis believed that the pro offer he made in LA meant he had immunity in the Las Vegas case as well. I base that opinion on the release of his memoir in 2019 and the multiple public statements and interviews he's given since he gave the pro offer. Unfortunately, however, the pro offer made in LA does not apply to the Las Vegas case. So again, in May 2019, believing he had immunity, Davis released his memoir, Compton Street Legend. In the memoir, Davis provides specific details about how and why Tupac was murdered. So here's just a bit of advice. It's not legal advice, just paralegal. But if you're going to confess to crimes in a memoir, make sure that memoir is not released until after you have passed away, because I guarantee you any statements admitting guilt in that crime can and will be used against you in a court of law. Just ask Davis. But I truly believe Davis thought he couldn't be charged in connection with the murder. So, unfortunately, because of that belief, it's highly likely that Davis could spend the rest of his life in jail for the murder. I say highly likely. That's my opinion based on just what we know so far. Obviously, when we get to the time of trial, that could change. Some of the statements made by Shook, in my opinion, could create reasonable doubt in the mind of a jury, but we will find out. More hydration. Everybody hydrate. Or I should say caffeinate. That's my caffeine. I do have water, folks. Just side note, I try to drink 100 ounces of water a day per my doctor's advice. I'm kind of on a weight loss journey because I have to have a back surgery in probably January. So goodness, I hope I don't look like death when I come join you all here. But again, I digress. So Davis has stated in his memoir that he and Knight are the only two directly involved in the shooting that are still alive. Law enforcement also believes this to be true, as Knight was the victim of the crime and the others in the car with Davis are all deceased. That leaves Davis holding the bag. All because he decided to tell his story, his truth. Davis wrote in his memoir, and I do have to read this one line for line, I tell my story with the utmost confidence because, as Winston Churchill once said, the truth is incontrovertible. Malice may attack it, ignorance may deride it, but then in the end, there it is. There are multiple other areas within that book and in some of the interviews he's given that states that he is telling the truth about what happened to Tupac that night. Yet in the motion we're going to go through, he's claiming that those are not admissions of guilt, but that they were made purely for entertainment purposes. You'll have to let me know what you think. So fast forward now to July 17th, 2023. I live outside of Las Vegas in a suburb, Henderson. So I first learned of the execution of a search warrant on a home here in Henderson through our local social media neighborhood groups. At the time, I didn't know who the search warrant was on, what it was for, but I am one of those nosy neighbors who want to know all things related, especially considering during the search warrant, the parties inside the house were told to come out with their hands up, etc. So it wasn't just a quiet search warrant. It's very interesting. If you haven't seen the videos, I do have it and can share with you too. Let me know. But anyway, what happened on July 17th was our Las Vegas Metropolitan Police Department served a warrant at Davis's wife's home. It's the home that Davis resided in up until his arrest. So when it hit the news, I was shocked. I was like, seriously, Tupac? Initially, we thought it was Suge's house. Reason being is local legend has it that on the balcony of that particular house, you can see the ghost of Tupac. I've been by it a few times to date. I've not seen the ghost of Tupac. If that changes, I will definitely let you know and probably be in therapy for multiple years because I saw a ghost. Not saying it's not possible. I'm just saying I haven't seen one. So, court records, grand jury transcripts, state that investigators found two giant bins of photographs, photo albums, magazines, and numerous clippings of the murder of Tupac, some dating back to 1996. Those items were seized. Also taken were computers, hard drives, and a copy of Davis's memoir. It's also been reported that bullets similar to those used in the Tupac murder were confiscated as well, but the tests from those bullets were not a match to the murder. I would be amazed if Davis still had bullets from 1996, but considering everything he kept in relation to the murder, anything is possible. And I apologize, folks. I need to break for just one moment. I will try and find some background music for you. I have a granddaughter who is very, very sick, and my daughter is calling to give me an update. So please give me just a moment. Let's find some music first, shall we? What do we like? Do we like this one? Okay, maybe not. Oh, that's a background. That's not music. Let's go try music. Oh, that's music. Oh, nope, don't like that one either. How about that one? All right, guys, I will be right back as soon as I find my mouse. Oh, let me turn off the music, guys. Oh. Okay, sorry about that. I have a medically fragile 5-year-old granddaughter. She was born 12 weeks early, so she's got some lung issues. They've gotten better over the years, but she came down sick last night. So my daughter was just calling to let me know that she has tested positive for the flu. So please keep her in your prayers, well wishes, whatever you believe in, simply because she is a little girl that a common cold can land her in the hospital. So hopefully they've given her some medication. She's going to be sleeping, but I certainly hope she feels better for Santa to come visit. But again, apologize for the break. Let's jump back into our story and get to the pleading. So we went through what the law enforcement officers seized from the home, if I recall, and I've lost my mouse again. Let me find it. This way, I think it is. So my husband will teach me how to use the 3 screens at some point. I hope, because currently I still cannot find. Well, my mouse is on the wrong screen. I'll get better at this, I hope. So let's see. So after the search warrant, law enforcement was extremely tight-lipped. I don't know what just happened there. No, go back here. So again, extremely tight-lipped. Those of us that live here, I think the national news picked it up too. We're all wondering what was going on. Of course, it came out that it was Keefe D's home. So there was lots of speculation there, but none of us knew the facts until the arrest on September 29th, 2023. Davis was arrested without incident and charged with one count of murder with the use of a deadly weapon with the intent to promote, further, or assist criminal gang in connection with the Tupac murder. So I've watched the court docket since the arrest because I work in the legal field here, so I can access the pleadings pretty easily as long as the matter's not been sealed. And with the public interest, it's not been, thankfully. So I've been going through the grand jury transcripts as well. If you guys want to go through them here, let me know. I will be happy to. And let me see. I think I've done something wrong here again. Oh, let's not do that. Okay. All right. Sorry. I'm learning what all my buttons are for. So with the transcripts, pretty interesting, and they do fill in some of the blanks of what law enforcement, the district attorney believes they will prove at the time of trial. So again, kind of interesting information. Let me know because there's 5 or 6 different transcripts. It was over multiple days. But anyway, Davis has pled not guilty. Trial is currently scheduled for June 3rd of 2024. If that goes forward in June, I hope to share and watch it with you all. The only reason I say currently scheduled is in a murder trial of this magnitude, it's not unusual for one side, the other, or even both to not be ready for trial on the first setting date. So I wouldn't be surprised if it gets moved. The district attorney's office has stated that they are not seeking the death penalty against Davis. He is being held currently here in the Clark County Detention Center, with no bail. This is also normal in murder cases here in Las Vegas that murder suspects get no bail. I've personally never heard of a murder suspect being OR'd from jail. That doesn't mean it hasn't happened or can't happen here. It just means I've not heard of it. In fact, very seldom do I even hear that a reasonable bail for a murder suspect is granted. But again, not unusual. Sometimes it will occur. Definitely not unusual for defense attorneys to at least ask for bail. Their job is to zealously represent their clients, and getting them out of custody early on is one of their hopes. Many years ago, I worked with a family / criminal law brother duo, and the criminal defense attorney in the office often did capital cases. And I remember at the time going, how do you defend these people with the evidence? Because I was having to go through discovery and some of the photographs were horrendous. And he literally looked at me and said, because if I've done my job and done it well, any verdict won't get overturned on appeal. And I was like, that makes sense to me. And I've kind of followed that when I do anything in criminal cases, obviously not doing capital crimes here in Las Vegas. But who knows, working in family law, some weird, scary things happen. I sincerely hope nothing like that ever happens. Several years ago, maybe we'll cover that in another one, there was an incident where a spouse was shot on the courthouse steps, and the judge was also shot. This was up in Reno, I believe it was. And that particular judge has traveled down here to Las Vegas to fill in for judges that are out on vacation, sick, etc. We did have a family court judge who last year passed away, and he filled in for him until there was a new judge sitting. So he has some interesting takes, and surprisingly, even after being shot, some of his rulings shocked all of us in the legal community, but that's a story for another day. So what happened after his arrest is that Knight gave to TMC a jailhouse interview. And Knight Shug gave a TMC jailhouse interview. Get it right, Leah, get it right. In the interview, Knight said, "I'm not going to get on the stand and testify. 1000% I won't go." Knight also said, "But I tell you this, I never had anything bad to say about Orlando," meaning Orlando Anderson. "He wasn't the shooter." Knight, however, continues to refuse to tell us who he knows was the shooter. In fact, he said there were only two people in the car, and Pac's not going to be able to tell the story. I ain't going to tell his story. So there we have it. The other surviving victim is not going to testify. It's my understanding that's kind of the street code. Even with rival gangs, you don't testify against each other. Plus, again, Davis and Knight were childhood friends, so that could factor in as well. I have to admit, if one of my friends shot and killed another friend of mine and hit me in the head, I don't think I would be so forgiving, and I would definitely be talking, but that's me. So there you have it. There's the timeline. So the motion we're going to go through was filed on December 14th of this year. The hearing is scheduled for January 2nd. Again, I have filed my media request to get access to the pool camera. I have also strongly considering going to the hearing in person so I can give you my thoughts and opinions on that. The problem there is I haven't quite figured out if I am granted stream access, how to be in the courtroom at the time of the hearing and cover it live with you guys, because recording anything inside the courtroom and live streaming in particular would land me in a cell next to Davis, probably with a hefty fine. So I will figure all that out and let you know what we're going to do. So are you guys ready to go through the motion? Let me see. I need to bring it up here. Share screen. Share screen. How do I share my screen? Oh, there's the start. Okay. And no, let me see. Oh, Leah, you know how to do this, really. Uh, Share screen. There it is. All right, let's find what we're sharing. There we. Okay, come on. Ah, there we got it. Can I move myself? Let's see. Can everybody see it okay? All right, let's see if I can. I don't know how to move me. Let's see. Oh, that's too small. That's not going to work. Can we do it this way? No. Sorry, guys. I'm going to figure this out. Promise. There we go. That's the best I can do. I am sorry. Let me get my mouse to cooperate again. There it is. Okay, so today we're going to cover defendant's motion for release on his own recognizance or in the alternative to set reasonable bail. So the opening is Duane Davis requests to be released on his own recognizance pending trial. In the alternative, he requests this court set reasonable bail not to exceed $100,000. They allege he's not a threat to the community and he's not a flight risk. This court can impose pretrial electronic monitoring if this court has any concerns regarding the safety of the community or whether Duane will return for his required court appearances. Again, kind of interesting there. So just a side note to Davis's public defender, this notice of motion does not have to be included in motions anymore. The clerk of court now issues the notice of hearing, but his public defender is not the only one that still includes it. I see it in our family cases all the time and kind of giggle. Again, as a paralegal, I have to know the rules. So then we have the attorney, the public defender, which really quick, Davis in his book alleges to have made a lot of money in his gang slash drug enterprise. So the fact that he has a public defender is kind of interesting. In his book, he does talk about a lawyer who's represented him in California in multiple cases that he really likes. So we'll see if that attorney puts in an appearance. Again, would have to have somebody here in Nevada who's willing to back them to do though. So unless he is licensed to practice here in Nevada. But it's just a declaration that states, he's filing the motion on Davis's request that the representations contained in the motion are true and correct based upon the information and belief and to the best of counsel's recollection. I find it interesting that it's counsel's recollection and not Mr. Davis. States that he still remained, that Davis is in custody here and that no bail, and that he's requesting bail be sent in an evidentiary hearing under this case law, which is Valdez Ramirez versus 8th Judicial District Court. It's basically what we follow here in regards to setting bail. So let's go through this part. So here's where it gets interesting, folks. On September 29th, 2023, the grand jury indictment was filed charging Duane with murder with use of a deadly weapon and the intent to promote, further, or assist a criminal gang in connection with the death of Tupac Amaru. Sorry, can't pronounce his middle name. Not sure. I don't want to get it wrong. Shakur, aka LaShawn Crooks. I must admit, I knew Tupac's name was different, but I didn't know it was LaShawn Crooks. So he's been charged with the murder from September 7th, 1996 in Las Vegas, Nevada. So after the indictment was filed, the state requested and was granted a no bail arrest warrant, and he was taken peacefully into custody on September 29th. During the initial arraignment, of course, he pled not guilty and waived his statutory right to a trial within 60 days. And the state indicated that it wouldn't seek the death penalty. Now, Davis waiving the 60 days is not surprising to me. Again, we're talking about a murder that happened 27 years ago. So while Davis knows what occurs, law enforcement, the district attorney has their evidence. I'm sure there's much more to flesh out, especially since Suge is still not talking. So it'll be interesting to see how that plays out. So on November 7th, they entered into a stipulation to extend the time for Davis to file his writ of habeas corpus up to and including December 26th. Side note, they've entered another stipulation to extend that until I believe it's January 24th. I will confirm that date shortly. So, and then trial date. So here's kind of where it gets interesting. So they allege that that the grand jury received testimony and evidence over 8 non-consecutive days from July 27th to September 28th. And I think earlier I said 5 or 6. I apologize. There are 8. So here throughout the rest of the motion, they're going to refer to the grand jury transcripts as GJT, volumes 1 through 8. So I will still probably call it grand jury transcripts simply because those letters would tongue tie me even worse than I've already been. But based on the testimony presented to the grand jury, the state is alleging that Duane Davis was involved in the murder of Shakur. In summary, the state is alleging that on September 7th, 1996, Duane orchestrated the shooting and provided the weapon used to kill Shakur in retaliation for Shakur and members of his entourage attacking Duane's nephew, Orlando Anderson, at the MGM Grand Casino earlier this year. Also, I do find it interesting that his defense attorney uses his first name instead of defendant or Mr. Davis, and that could be speculation to personalize Davis more to the court. I can't say. Every attorney has their own writing style, so maybe that's just how this attorney operates. But then he goes on to write that during the grand jury proceeding, the state presented an astounding amount of hearsay and speculative testimony. So keep that in mind. Hearsay. Now, Davis's own words aren't necessarily they're not hearsay. Now, if somebody got on the stand and testified saying, "I heard Davis say this," that could be hearsay. So what the hearsay and speculative testimony, according to Davis's attorney, is that Marion Suge Knight was the president of Death Row Records, and Shakur was a Death Row Records artist in September 1996. I don't think any of that's going to be in dispute. According to the state, Death Row Records was aligned with the Mob Piru Blood Street gangs from Los Angeles. And if I'm pronouncing the name wrong of the gang, I apologize. The gang was from Las Vegas, California. Roger Neckbone Williams, Alton Buntry McDonald, James McDonald, and Trayvon Trey Lane were members of the group. That's in the transcript. Where you can find it is here in the transcripts. I do have them. If we don't go through them here, I will share them with everybody so you can read them for yourself. So the state alleges that the two groups, including the Southside Compton groups, were rivals. I don't necessarily think that's an allegation. I think there's enough facts to support that. But again, nothing's been proved conducively as to that, I suppose, in our court. So apparently the Piru Street gangs were financed by Death Row Records to provide security for Knight and Shakur. Davis does state that in his memoir as well. So right now it is an allegation. Security was also provided to Death Row Records, Knight and Shakur by Reggie White Jr. Keep in mind, that's who Knight says the shooter was. So that's kind of interesting to me. And Wright Jr. was a former Compton, California police officer, and other police officers hired by Wright Jr. under his company, Right Way Protective Services. So I find it interesting that that alleged affidavit by his attorney says it was Reggie White and Knight's ex-wife who orchestrated the murder, when according to Davis, Wright was employed by Death Row Records. So that'll be interesting to see if that's fleshed out in this trial or not. So then it goes on. Duane Keefe D Davis, Orlando Baby Lane Anderson, DeAndre Big Dre Smith, Terrence Bubble Up or T-Bone Brown, and Devonta Dirt Rock Lee were all members of the Crips, Southside Compton Crips street gang from Compton, California. The Southside Crips were allegedly aligned with Sean Puffy Combs, who had his own record company, Bad Boy Records, for which Christopher Notorious B.I.G. Wallace was an artist. That's not an allegation either. That's fact. Now, I admit, surprising to most, especially my husband, because I'm also a country music fan, but in the 90s, loved all their music. Tupac, Notorious B.I.G., listened to them all. So, but back to the pleading here. Through the testimony of witnesses with questionable credibility, mainly Devonta Lee and Reggie White Jr., which I find interesting since Reggie White Jr. used to be a law enforcement officer, but in the grand jury transcripts, there's more about him. Also, Davis's book goes into quite a lot of detail about Wright. But anyway, the state introduced evidence insinuating that the dispute in the rap world between Death Row Records and Bad Boy Records became intertwined with the alleged animosity between the Southside Compton Crips and Mob Piru. The state alleged that this intertwined dispute escalated with a fight that occurred between Trayvon Lane, Orlando Anderson, and other associates of Lane and Anderson at the Lakewood Mall in Lakewood, California. According to Lee, in September 1996, Anderson and a member of the Crips beat up Lane and members of Mob Piru. During the fight, Lane's Death Row Records chain was stolen. Lee alleges this incident escalated the animosity between the Southside Crips and the Mob Pirus. The police allegedly responded to the fight in the mall, but the state did not produce any police reports or mall security reports detailing the incident. So that's kind of interesting. We'll have to see if they have all that. I'm sure they do. And then on September 7th, 1996, Mike Tyson fought Bruce Seldon. I did pronounce his name wrong all the way through. I apologize. At the MGM Grand Casino in Las Vegas. The fight was attended by several thousand people, including Knight, Shakur, and Lane, members of Death Row Records, and members of the Mob Piru. The state also alleged that Anderson, Duane, and other members of the Southside Crips were also in attendance. Davis says the same thing in his memoir and the interviews he's given, but I digress again. Immediately after the boxing match ended, an altercation broke out in the elevator core lobby of the MGM, where Knight, Shakur, Trayvon Lane, and other members of Death Row Records' entourage got into a fight with Orlando Anderson. There is video of that is all over the internet. Again, let me know if you want me to pull it and share it with you guys too. The state speculated, but never provided proof to the grand jury that the fight was retaliation for the alleged fight at the Lakewood Mall in California. Interesting. I'm sure that I'm going to guess the DA is going to be able to tie all that together, but we'll see when we get to trial. The night after the Tyson fight was over, Knight and Shakur were traveling eastbound on Flamingo Road and Covo Lane when they stopped at a red traffic light. Davis was driving a black 1996 BMW four-door sedan, and Shakur was seated in the right front passenger seat. Several other vehicles in Knight's entourage were following Knight and were stopped at the light behind him. A white four-door Cadillac pulled up next to the passenger side of Knight's vehicle, and shots were fired from the Cadillac toward Knight's car. Scroll up a little bit here. Knight was struck in the head by a bullet, and Shakur was struck multiple times on the right side of his body. Shakur was transported to UMC Hospital. He died on September 13th, 1996, and his death was ruled a homicide. That's fact. That's not allegations or speculations. That's undisputed, in my opinion. The state did not, according to Davis's attorney, introduce any independent evidence connecting Duane Davis to the shooting. Oh, we have a footnote. Let's see what the footnote says. Retired Los Angeles police officer Robert Ladd alleged that in 1997 he searched Duane's house and found a Monte Carlo hotel bill, which he alleges proved Duane was in Las Vegas on September 7th. However, the actual bill itself was never authenticated nor introduced into evidence for the grand jury. I'm sure when we get to the trial, the actual murder trial, that bill likely will have been authenticated if possible and will be introduced at the time of trial. But let's scroll back up. Sorry, folks. Okay, let's see. So we got through the footnote. So instead, according to Davis's attorney, the state relied on excerpts from a book titled Compton Street Legend, which was allegedly written by Duane Davis and Yusuf Jah. I like the fact that now they're claiming this memoir was allegedly written by Davis and his ghostwriter or assistant. The state did not delineate which parts of the book, if any, were written by Duane. That's true. I from what I've read, I guess at the time of trial, maybe we'll hear from Yusuf. I don't know. Additionally, the state admitted several video clips of interviews of Duane taken from YouTube video bloggers. That's true, they did. According to the book, Duane learned Anderson was assaulted by Knight and Shakur. Duane, Brown, Smith, Big Dre, and Anderson set off looking for Knight and Shakur in a white Cadillac. Allegedly, Brown was driving and Duane was in the front passenger seat, and Dre and Anderson was in the front passenger seat, and Dre and Anderson, I think they broke that off, but probably in the back seat. In the book, Duane said he planned to confront Knight over the altercation that occurred at MGM earlier that night. Excuse me again. Ugh. So those attorneys that talk for hours at opening and closing, I don't know how they do it without having hydration. But back to our pleading. According to the book, Duane did not plan to kill Shakur and Knight in retaliation for the fight. He had a gun in case his diplomatic approach to resolving the situation didn't work. That is written in the book. According to the book, let's get it up here so we can stop scrolling. According to the book, Duane's car drove up to Knight and Shakur on Flamingo Avenue. Again, not disputed. The cars, whether or not Duane and Anderson were in the cars, I guess, is yet to be proven 100%, though we're pretty sure it has. But that's fact. Did drive up. Then he goes on that the book described the moment the Cadillac pulled up along Knight's car like two rams locking horns. Shug and I looked each other dead in the eye, our eyes locked. The terrified expression on Shug's face read, "Damn them," not going to say it, inward. Next, it's alleged in the book that Shakur reached for a gun. At that point, someone from the back seat of the Cadillac shot at Knight's car, hitting Knight and Shakur. In his YouTube interview on Art of Dialogue, Duane said Anderson was the shooter from the Cadillac, which was widely held public belief. Again, law enforcement thought for years that Anderson was the shooter. So I guess law enforcement, and according to Davis's attorney, the public's belief as well. Let's go to the next page. Okay. On July 17th, 2023, the Las Vegas Metropolitan Police Department SWAT team executed a nighttime raid of Duane's home in connection with the case. We have another footnote. We'll go down and look at that. Again, not disputed. I heard about it before we knew what it was for. Let's go look and see what the footnote says. Oh, it's a link. Shall we look? Let's look. If I can get it to work. Oh no. Okay, we will come back and look at that once I figure out what needs to be done. But back up. Okay, got that. There we go. Sorry, folks, for the scrolling. At the time the warrant was served, according to Davis's attorney, Duane was given notice of an intent to sink indictment, notifying him that the district attorney intended to sink an indictment against him for the crime of murder with use of a deadly weapon in connection with the murder of Shakur. See, Maricom notice attached as Exhibit A. We'll go down and look at that when we're done here, definitely. Duane did not flee the state or attempt to avoid arrest in any way, despite knowing his arrest for a murder allegation was imminent. That's interesting to me, and actually, until I read this particular motion, did not know that Davis knew that he was likely going to be arrested for the murder. He didn't flee. In fact, he was out taking a walk in his neighborhood when he was arrested. I do know that Davis has, over the past several years, had some pretty bad health scares, including a bout with cancer. And one of the reasons he cites for doing his memoir and the interviews is that he has nothing else to lose. So I don't know what his health is currently, but later in this motion, his attorney does state that being in jail is negatively affecting his health. Can say, personally, if I was in jail, it would probably negatively affect my health as well. I'm claustrophobic. It wouldn't be pretty. I have had to go into jails um, as a role as paralegal and talk to inmates. Most of the time I'm with an attorney. We are in a separate room and it's not too bad. It's a room. At one point, way back in my early days, I was in California and I had to go speak with someone on death row in San Quentin. Because I wasn't a lawyer, I wasn't allowed to have the lawyer room per se. So I had to meet in the main visiting area, and absolutely terrifying because you are pretty much locked into a large cage with the inmate. I had never spoke to the inmate before. I do know that he had been convicted of serial murder and he tended to like redheaded women. I'm a redhead. It was kind of interesting. It was an interesting case. Not going to name it here. He is still on death row currently. I will say during that visit, as I was freaking out because I'm claustrophobic and trying to get it all under control, which I did, I had this really bad cold chill and just freaky feeling, and I thought it was because again I'm locked into a cage. Basically, it was a good size cage, but still a cage. I had done the vending machine thing and got snacks for the person I was meeting with, but something just felt off. The gentleman next to me, and this is a whole nother story for another day, in the cage next to me, I should say, because I was still waiting on the person I was seeing to be brought out, asked if I was okay. Apparently, I was pretty pale. The officers were very nice in making sure I was okay as well. And he's like, "Are you okay?" And I was like, "I'm thinking it's just because I'm claustrophobic, but something just doesn't feel right." And he said, "No, that's not it." An officer who was standing kind of checking on me kind of intervened and said, "Hey, just turn your head." Back in those days, I could turn my head. It was before my neck surgery. And when I turned around, I swear to you, I was looking at pure evil. I I I'm not overly superstitious or anything like that, but I got an absolute cold chill down my spine. Um, it was an inmate who was visiting with his, I believe they were married at that point, wife. Because of who he was, they had to do it between glass, so they were on the phone. He was looking at her. I don't think he was looking at me, but I saw his eyes. We had a good distance, but I was younger. I had great eyesight then too, and I just felt like I was looking into pure evil. His wife, I had talked to while waiting to be brought in. She's very nice lady, truly loved this man, even though she acknowledged he was a monster. She was sweet. I'd met her a few other times over the years. So it was the officer who said, a lot of people feel this way when he's around. And it took me a minute to register who I was looking at. I was looking at Richard Ramirez in the eyes. We were separated by glass. He wasn't paying attention to my existence, but it was truly the only time in my life I ever felt like I was close to something that was pure evil. So there's that story, but sorry. I digress. Let's go back into the pleading. Instead of my life story as a paralegal, I do have some interesting ones I look forward to sharing with you all as the channel grows. Again, thanks for joining the first live in replay crew. Appreciate you all for stopping by to watch as well. Please do the like and or subscribe button. I'm going to try and grow a community here where we can have honest discussions and give our opinions in a respectful manner. And the only way to do that is with your help. All right, so let's get into the argument and case law. I will kind of probably scroll through it pretty quickly because you don't want to hear all the names of the cases. Likely, I know when I'm reading them or having to draft a response to a pleading, most of it in family law, I know what the case law is, so I don't have to read it. I haven't had to do anything in a murder case in a while in Nevada, so we may go through some of it just because it could have been updated since the last time I had to do anything. But the first thing is in A, both excessive bail and excessive release conditions violate the United States and Nevada Constitution. Excuse me while I hydrate some more. So it says the Eighth Amendment of the Constitution states in relevant part that excessive bail shall not be required. The Nevada Constitution likewise outlaws excessive bail. Bail amounts must be reasonable and not more than the defendant can be expected to provide. The Nevada Supreme Court addressed this issue in the case of Ex parte Malley, and in that the court stated, in support of the contentions made by petitioner, reliance is based upon ex parte Jaggles and Varnis, and it gives the citations. There is little in the matter mentioned to aid us in the one before us. It is true that we said in that matter, that it was the purpose of the constitutional provision mentioned therein to prevent the fixing of a bail bond in so great a sum as it precluded its being given, and that it was the idea of the framers of the Constitution that punishment should follow conviction and not both precede and follow it, or be inflicted in spite of possible acquittal. So this does bring up the interesting issue of bail and holding a suspect before they've been to trial, because again, in this country, you are innocent until proven guilty. But yet you can spend months, if not years, in jail waiting for your trial. So this is not a new argument. It's one that's given often, but I just find it interesting. So again, it says, the purpose of bail is not to punish the defendant for charges for which he has not been convicted. The purpose of bail is to assure the defendant's return to court. In Ex parte Jangles and Varnis, the Nevada Supreme Court, let's go to the next page, stated the Constitution provides that excessive bail should not be required. In reaching a conclusion as to what is reasonable bail, a court should consider that the subject of bail is simply to assure the presence of the accused for trial. And then it gives the citation again. The amount of bail in any given case must secure 1, community safety, and 2, the accused's presence at a criminal proceeding against them. Excessive bail is a bail set at a figure higher than an amount reasonably calculated to fulfill this dual purpose. Release conditions also fall within the purview of the Eighth Amendment and may not exceed the purported threat posed by a particular defendant. As with bail, then release conditions must not exceed that which is minimally necessary to 1, ensure protection of the community, and to 2, secure the accused's future appearances in court. So, yeah, I understand the reasons for bail. I work in the legal field. Hopefully that explains it a little more for you. But what do you think? Do you think that if it's granted that Davis will return for trial? At his age, I think likely he would. He wants to clear his name if at all possible, but I guess we'll see. I also don't know if he still has any gang affiliations that could help him, say, disappear. I just don't know. But let's go on. So B, Valdez Jimenez versus 8th Judicial Court. On April 9th, 2020, the Nevada Supreme Court brought Nevada bail practices in line with constitutional law. That particular footnote, number 3, is just the law and or I'm sorry, the case and the citation. In that matter, as Davis's attorney writes, the court acknowledged that for an accused, the presumption of innocence demands presumption of release without monetary bail. So this is where they're going to argue that Davis be let out on OR, which kind of then reduces, there's no money on the line, so disappearing wouldn't come with a financial consequence for whoever posted the bond. But let's continue. Valdez Ramirez makes clear that requiring accused to prove his or her right to release without monetary bail is unconstitutional. And 2, the state must affirmatively demonstrate that bail is necessary to ensure the defendant's presence at future court hearings. As such, where the state seeks pretrial detention, a judge may impose bail only if, with emphasis added, the state proves by clear and convincing evidence, let's go to the next page, that it is necessary to ensure the defendant's presence at future court proceedings or to protect the safety of the community. I'm going to guess footnote 6 is more case citations, but let's look. It is. Okay, we're right here. So, procedural due process makes no distinction between an accused charged with first-degree murder and accused persons charged with lesser crimes. A first-degree defendant, that's awkwardly worded, must be accorded the same process due all other criminal defendants, including the processes outlined in Valdez Ramirez. I agree. It doesn't matter what crime you're charged with. You should have the same processes available to you. That doesn't necessarily mean that I think a murder suspect should be released on his own recognizance. So let's continue. Specifically, a person charged with murder must be admitted to bail where neither evident proof nor presumption great of guilt exists. Okay. So they are obviously alleging that what the state provided to the grand jury to get the indictment does not offer proof nor presumption of guilt. Presumption great of guilt exists. That is a tongue-tied. Thank you to the Nevada Supreme Court for that language. Our state constitution does not unceremoniously and irrevocably destroy an accused's liberty rights. The state must justify limiting accused right to bail. So then it says, a prompt. The justification begins with the Valdez Ramirez hearing. At a prompt adversarial hearing, the state must meet its clear and convincing evidentiary burden. Then he bolds, a judge must consider these factors set forth in NRS 178.4853, which is our statute regarding bail. And if monetary bail is deemed appropriate, an accused financials resources. Oh, we must have missed a footnote. We'll have to go back and maybe look at that. So again, he emphasis added. Let's go. To be clear and convincing, the state's competent, lawful evidence must produce in the mind of the trier of fact a firm belief or conviction that the state's allegations are true. The clear and convincing evidence threshold exceeds a mere preponderance. State representations are not evidence. That means the state must substantiate its criminal history allegations and demonstrate the willfulness of any prior failure to appear. To the extent it relies on the seriousness of the charge, the state must demonstrate how the charge itself bears upon community safety or future appearance in court. Additionally, the state must provide the defense with all information upon which it will rely in seeking continued detention so that an accused may meaningful rebut the state's evidence during the adversary hearing. Discovery. The state has to give the defense what they have. The defense has to give the state what they have. So he's correct there. Here's the statute. And let's see. So according to the statute, if the defendant is admitted to bail, the bail must be set an amount which, in the judgment of the magistrate, will reasonably ensure the appearance of the defendant and the safety of other persons and of community having regard to. So the factors the court has to consider is the length of his residence in the community. I'm not sure how long Davis has lived in Las Vegas. I'll have to research that one. The status and history of his employment. I'm not sure what that is either, but I'm sure his attorney's going to tell us. Relationships with the person's spouse and children, parents or other family members, and with close friends. We know Davis's wife lives here. Not sure who else. Number 4, reputation, character, and mental condition. Let's go to the next page. Number 5, prior criminal record, including without limitation, any record of appearing or failing to appear after release on bail or without bail. Number 6, the identity of responsible members of the community who would vouch for the reliability of the person. Number 7, the nature of the offense with which the person is charged, the apparent probability of conviction, and the likely sentence insofar as these factors relate to the risk of not appearing. The nature and seriousness of the danger to the alleged victim, any other person, or community that would be posed by the person's release. Now, 8 is kind of interesting, and I'm going to guess, again, speculation. The state may key in on this as Davis has admitted to being a gang member. He stated he got the gun that killed Tupac. He's admitted to a lot of pretty serious crimes. He's done prison time before. So I don't know if the state's going to try and key in that he is a danger to anybody who could testify against him or not. I guess if and when the state files their opposition to this, which I'm sure they will, we'll know more and we'll go through that when it's done. So number 9 is the likelihood of more criminal activity by the person after he is released. Going to, again, speculate the state's going to key in on that one. And any other factors concerning the person's ties to the community or bearing on the risk that that person may willfully fail to appear. Side note, I have to write pleadings every day. I don't usually have to go and read verbally the case law associated with them, so that was a mouthful. But C is where we're going to see how Davis's attorney applies the law to this particular case. So, I really need to stop saying the word so. But in the motion, his attorney writes, Duane should not be denied bail in this case. It cannot be said that the proof is evident and the presumption great that Duane is guilty of first-degree murder for the death of Shakur. So they don't think the state can prove it or has evidence to prove it. I think even the state says he is not the one who pulled the trigger that night, but they do allege he is the one that kind of orchestrated it all. They got the gun. It was his call that they went to the club and waited. And basically, he's admitted to being the person who told the driver of the Cadillac to turn around. So that's what the state's alleging. We'll see if the state can prove it when we get to trial. So they go on that this court should release Duane on house arrest with electronic monitoring pending trial. Monetary bail is not necessary to secure his attendance at trial or protect the community. Let's see why they think that way. So the court should not deny Duane bail because the state cannot meet its burden to show the proof is evident and presumption great that Duane committed first-degree murder. So I'm sure, I don't know if any of you are curious as if the state does not believe Duane pulled the trigger, how he's charged with the murder. Lots of times in cases like this, or even other cases involving where there was another felony, say a robbery, and two or more people are involved, but only one person actually committed the murder, all of those parties can be charged with murder because they're there. I recall a case, I don't remember the name, I apologize, where there was a robbery. Somebody was shot and killed. The person who was the lookout was outside, did not know what was occurring on the inside, but was ultimately charged with murder. I don't even recall how that case turned out. I just remember it was interesting at the time. It was probably 20 years ago that I heard about that one. But back to our motion. So according to Davis's attorney, Duane is entitled to bail in this case because the state cannot meet its burden to show that proof is evident or the presumption great that Duane committed the crime of first-degree murder. It is uncontested that Shakur was shot on September 7th, 1996, and died several days later from injuries sustained in the shooting. However, Duane's involvement in the shooting and the motivation for the shooting is less clear. The evidence presented to the grand jury was based on hearsay and highly, let's go to the next page, prejudicial, and speculative evidence. Many of the witnesses who testified before the grand jury lacked firsthand knowledge of the events that they ultimately testified. Excerpts from the book Compton Street Legend that were read into the grand jury record, as well as YouTube clips admitted as exhibits, seemingly connect Duane to the shooting of Shakur. However, the value of these items of evidence is questionable. I am out of caffeine, so on to the water. So next, first, Duane was initially connected to the death of Shakur through coercive tactics and a secret recording by Greg Kading. I find that interesting as it was a pro offer, and I know a lot of interrogation rooms, anything going on in those rooms is recorded, so I'm not sure how it was a secret, but hopefully they'll tell us either in this motion or at the time of trial. Then it says in 2008, members of a federal task force, including Greg Kading, and I could be pronouncing his name wrong, I'm not sure, Jeff Bennett and Darren Dupree, Timothy Seawright, and others from the FBI, DEA, and LAPD approached Duane regarding a federal drug case it was building against Duane. Let's scroll a little bit here. The task force threatened he would go to prison for life unless he admitted to involvement in Shakur's death. Duane was offered immunity in exchange for admitting to being involved in the death of Shakur. Information from this immunity deal was released into the public by Greg Kading. Oh, we got a footnote. Let's see what this footnote is. Oh, probably a link to the book, but I will post this pleading up too. So in the description, I'll provide a link. So if you want to read it and maybe click on the links, hopefully I can figure out to do that. Okay. So then it says Kading secretly recorded one of the interviews and went on to write a book and movie and produce a mini series from the recording. And that another footnote with a link. Duane decided to become involved with the publishing of the book Compton Street Legend and to give interviews for money after watching Kading profit from the situation. It has not been established which parts of the book, if any, Duane wrote. The second author listed as Yusuf Jah did not testify at the grand jury proceedings to delineate which parts of the book were Duane's words. It was obvious that the parts of the book are fiction and dramatized to make the book more marketable. So basically, they're claiming that Duane just admitted to being a participant in the murder of Tupac to gain monetarily, and that it was all fiction. What do you guys think? I don't know, especially based on him stating so many times that it's the truth, but we'll see. The book and video interviews were produced for financial benefit under the belief that Duane had immunity. There we have it. He believes his LA Pro offer had granted him immunity, so found that interesting. So Duane was paid a substantial amount of money to give his interviews to YouTube. See Reggie White's statement attached as Exhibit B. We'll definitely go through the exhibits, discussing how he helped Duane get the YouTube interviews and the typical payment structure based on views. The truthfulness of the content of the interviews was never verified. The books and interviews were done for entertainment purposes and to make money from a situation that Kading and others had already profited. What do you guys think? Do you think he was writing fiction, or do you think he was telling his truth? I It could create reasonable doubt, folks. It really could. It's possible. I think we're going to probably have to hear from Yusuf and see what he says, but I don't know if he's going to talk. I guess we'll have to find out. So here is where we get into what Suge had to say. So the most compelling evidence that Duane was not involved in the murder of Shakur comes straight from the mouth of surviving victim and the only living eyewitness, Marion Suge Knight. Oh, there's a footnote. What do we got about Suge? Oh, is his interviews. Okay. I got to quit looking at these footnotes or we're going to be here all day. So Knight is currently incarcerated in a California prison. This is true. Knight was interviewed over the phone by TMZ after Duane was arrested in the case. During the interview, Knight was asked, "They seem to be saying that Orlando was a shooter and Keefe was in on it, that he had full knowledge of what was going down, and it was revenge for Orlando getting beat up by Tupac and his team at the MGM after the Tyson fight. Is that correct?" To which Knight responded, "No." The interviewer then asked, "Who shot Tupac?" Answer, "It wasn't Anderson. That's all I have to say about it." Then in 2020, Knight did an interview with Michael Douglas Carbon. Link is in the footnote. Knight alleged that the people responsible for the death of Shakur were the same people responsible for the death of Christopher Notorious B.I.G. Wallace. Knight has insinuated that, let's scroll the next page, that Rafael Perez, Reggie White Jr., and Lydia Harris were behind the shooting that killed Shakur and wounded Knight. He specifically said that Orlando was not involved in the murder of Shakur. I find that interesting because, again, that alleged affidavit from his attorney says it was Knight's ex-wife and Wright who were involved. So whether or not this affidavit exists, I'm going to have to do a deep dive and find out. Okay, next. Despite being the only living eyewitness and surviving victim, the state did not have Knight testify before the grand jury. That's probably because Knight said he's not going to do it. And really, he's already in prison for 28 years, so they can't even threaten him with incarceration if he doesn't comply. But anyway, Knight's public statements have refuted Duane's alleged version of events as recited in the book Compton Street Legend and in the YouTube interviews. Knight and Duane grew up playing football together in Compton. There's the site to the transcripts. They played on the same team. Knight's father and uncle were the coaches. They've known each other for approximately 50 years. So that's all pretty true. And again, Knight's statements that it wasn't Anderson and that Davis wasn't involved, that can create reasonable doubt. And that's all. You just need reasonable doubt. and Davis won't be convicted. So what do you guys think? Do you think if what Davis's attorney is stating so far is true, that he's going to be able to stir reasonable doubt in the mind of the jury? I'm also curious to find out if Knight may testify at all, because he could come in to testify that it wasn't Davis and Anderson. I'm somehow, the impression I get is Davis isn't going to testify for either side. So I guess we'll have to wait and see. Okay, so then it says, if Duane's story in the book was true, that him and Knight locked eyes before Shakur was shot, Knight would have been able to identify Duane and Anderson. That's fact. If you looked into the eyes of somebody, then you probably know who fired the shot that hit you in the head. So then he goes on, even if this court was inclined to give the book and YouTube interview some weight, it does not establish the killing of Shakur was premeditated and deliberate. Davis, I don't know. Davis is kind of contradicting statements. Could support premeditation and it being deliberate. In the book, it is alleged that Duane planned to speak with Knight regarding the fight that had just taken place between Shakur's entourage and Anderson. Additionally, in one of the videos, Duane says they went looking for Shakur so Anderson could fight him one-on-one. True. If the books and interviews are taken as fact, Duane intended to resort to diplomatic measures as a response to Shakur and his associates' assault on Anderson. Shakur was shot in self-defense after he reached for a weapon. Nowhere in the book is it alleged Duane ordered anyone to shoot Shakur and Knight. That is true. He never says he ordered them to shoot. He does admit to giving them the gun and some other things that maybe he didn't specifically say, hey, shoot Tupac and Knight. It's pretty heavily insinuated in his book and the interviews. So the only other witness the state produced who purported to have personal knowledge of any of the incidents tied to the shooting of Shakur was Devonta Lee. Lee alleges that he was present for the Lakewood Mall incident. He also alleges that Dre told Lee that Dre shot Shakur. Dre's alleged admission after the fact is clearly prejudicial hearsay. I'd have to agree. Despite the testimony being inadmissible at trial, Lee will not be a credible witness. Let's find out why. All right, let's see. Notes from a 1997 interview between Lee and Los Angeles Police Department officers were provided in discovery. Those notes indicate that Lee told officers in 97 that he did not think Dre shot Shakur. See LAPD notes attaches Exhibit C. Oh, I'm looking forward to going through these exhibits. In fact, in 1997, Lee told officers that he asked Dre directly if Dre shot Shakur. Dre denied being the shooter. This information was never provided to the grand jury. In 2007, Lee was interviewed again by the federal task force. Lee never mentioned that Dre was the shooter in the 2007 interview. Okay, so according to Davis's attorney, the court should release Duane on house arrest with electronic monitoring pending trial, consideration of NRS 178498 and NRS 178.4853. Factors weigh in favor of releasing him on electric monitoring without monetary bail pending trial. While the state will present in its interpretation of the substantial facts, the defense respectfully reiterates that Duane is entitled to the presumption of innocence despite the severity of those charges. Okay, so his attorney's coming out going, we know they're going to oppose it and what they're going to say, but we still should have our motion granted. So not unusual. He acknowledges that the allegations are serious. However, even if the allegations presented to the grand jury are assumed to be true, despite the credibility and evidentiary issues, there is no evidence that he directed the shooting of Shakur and Knight. Further, there is no evidence or allegations that Duane is the shooter. This is true. Despite likely claims by the state to the contrary, Duane is not a danger to the community and he's not a flight risk. Do you guys think he's a danger or a flight risk? I don't know. He's older now. He has some health issues. I don't know. The state was made aware of Duane's alleged pro-offer connecting him to the case in approximately 2008 or 2009. However, there was no rush to arrest Duane. The state waited 15 years to bring the current charges. Any argument the state is likely to make regarding Duane's alleged dangerousness today is belied by the lack of interest in arresting him prior to 2023. That's an interesting argument. I hadn't looked at it that way. I might have to agree with his attorney there. Let's go to the next page. Duane admittedly has a criminal history. However, his prior history has mostly been related to drug possession and trafficking. True. He does not have a history of violence. Maybe no criminal history of violence, but he's admitted to a lot of violence. Or allegedly admitted, I should say. So further, a Nevada pretrial risk and assessment was not completed in this case. It's interesting. Based on defense counsel's belief and review of discovery, Davis has one conviction involving violence. In 1985, he was convicted of a misdemeanor for shooting into a structure. His other convictions are related to drug possession and distribution. Duane decided to walk away from the drug game in 2009 after he was approached by the federal task force. He has completely changed his life since then. All right, let's see. Get another drink. Let's see what he's done. Duane sought legitimate employment in 2009. He got a job as an inspector for the Mistress Group in Torrance, California. He performed well at his job and was employed there until 2014. However, in 2014, he experienced serious health problems. He went to the hospital after experiencing chest pain. He needed to have several stents placed to resolve his cardiac issues. While at the hospital, they also discovered he had colon cancer. He had successful surgery to remove the malignant mass as well as significant portions of his colon. His cancer is in remission, but he needs to have blood work done every 2 months and a yearly PET scan. Cancer is an ugly, ugly illness, folks. I don't wish that on anybody. After the scare in 2014, Duane worked hard to maintain his health. He changed his diet and began an exercise regime to keep his health issues under control and to prevent the reoccurrence of cancer. His heart issues were being maintained with the use of medication. All right. Duane's health has declined since being in CCDC. He is not getting his bi-monthly oncologist checkups. That's not good. He should be getting his checkups. I don't know if they're giving him other oncologist checkups, maybe not with his regular doctor. I don't know, but I absolutely would think that we would have a responsibility to the inmates in custody to provide medical care. Additionally, his heart health has declined. He was put back on a group of medications to try to get things under control. He is currently taking atorvastatin, enalopamine, metoprolol, Signate, and daily aspirin. Okay, I take atorvastatin for cholesterol, and enalopamine is a blood pressure med. I'm not sure what the other is. Aspirin is supposed to help prevent heart attacks. So it goes on. He has to take these medications in jail because he was unable to do things necessary to maintain proper health. His diet in jail is terrible. I will say, many, many years ago, I was inside the jail doing not paralegal work. This was like my early 20s. And I was told then that they purposely fed the inmates higher carb meals because it kept them more sedentary. So I don't know if there was truth to that. That was just what I heard way back in the day. So who knows? Let's see. He is being given heavily processed meals full of sodium that barely passes as food. I have heard that jail food is questionable. So his diet and lack of exercise in the jail, given his age and medical history, is negatively impacting his health. Okay, so the attorney is going through all these factors. So Duane's not a flight risk. As stated above, he was raided by the LVMPD SWAT team in July. He was given a warning that the district attorney was seeking an indictment, and he didn't fly or go into hiding. He stayed in Nevada. He does not have a passport nor the financial resources to flee the country. As stated above, he has serious health conditions that need to be regularly monitored. Going on the run would be a death sentence for him. That's possible. I'm really curious because he admits to making a lot of money in the drug world. What happened to that money? Was it seized? I don't recall. Maybe he tells us in the book. I really don't remember. Plus, he wrote the book and gave the interviews for financial gain. So maybe he has the financial resources. Maybe the state's frozen his assets. I don't know. So, second, Duane has substantial ties to the community. He has lived in Henderson for 10 years. I didn't know he lived in Henderson so close to me for that long. I really didn't. But then again, I'll be honest, I didn't know who Keefe D was until the search warrant. So, it says he has family support. He is married and has 4 children. He maintains a close relationship with all of his children. 2 of his children live in Henderson. He also has several grandchildren. I'm a grandparent. There's nothing better than being a grandparent. Feed them cotton candy, Mountain Dew, and send them home to mom and dad. He is also well regarded in his neighborhood. See character letter, Exhibit D. His neighbors knew nothing of his past because he had moved on from his old lifestyle. As his neighbor stated, he is of no threat to the community. So, based on the arguments above, Duane has established that less restrictive conditions, namely house arrest if deemed necessary, is sufficient to ensure that he will appear in court and he's not a flight risk. If the court disagrees with the same, then pursuant to NRS 178.498, subsection 2, this court must determine his financial ability to post bail. In candor, Duane does not have any substantial means of posting bail, and he has already been declared indigent as evidenced in part by the Special Public Defender's Office being appointed to represent him. So I have questions. If he gave the interviews and wrote a book for financial gain, what did he make off of these? I believe the YouTube was substantial, but I don't know how substantial. He said he made a lot of money in the drug game. I think he covers that in the book. Maybe it was seized. I don't know, but where's the money? So, conclusion. Duane Keefe Davis is entitled to reasonable bail. Excessive bail is prohibited by the Constitution of both Nevada and the United States and the foregoing applicable case law. All right. The main purpose of bail is to defend the return to face the accusations levied against him. Based on the foregoing, it is respectfully submitted that the court release him on house arrest with electronic monitoring or set a reasonable bail pending trial. Such an order will provide sufficient assurances that he will return to court and will protect the community. Let me know what you think. Do you think his attorneys put forth a good argument here? I just don't know if you're going to convince the judge that the interviews in the book were fictional. I'm torn. I think he was telling the truth. I really do. But I'm not the judge, and I'm certainly probably not going to be a jury in the case because I have opinions. I always have opinions. Let's certificate of service. This is required on all our pleadings here in Nevada. It says that we followed the judicial rules and made sure that everybody involved in the case, the other attorneys, were served. Here, they did in fact serve the state of Nevada. I checked this morning. The state has not yet filed an opposition to this, but I really look forward to reading it to see what they say before deciding definitively whether I think the motion should be granted or denied. My opinion, again, not legal advice, just my opinion and speculation. But based off this, I maybe bail. Again, the OR thing is questionable for me. Let's go look at the exhibitees, as Emily calls them. So this is what was apparently given to Duane when the search warrant was done. And it states notice of intent to seek indictment. So it does say that he could testify before the grand jury. Oh, that you may testify before the grand jury only if you submit a written request to the district attorney, include the address where the district attorney may send notice. You are intentionally notified that since the state is seeking to initiate a charge of open or first-degree murder against you by indictment, you may request that the court appoint defense counsel. It says you've already been appointed counsel in connection with this matter. It was served to this attorney as well. I didn't realize. I'm going to have to do some more digging. So was he appointed counsel before the search? If so, exactly when did he and his attorney know he was under investigation and likely to be charged? That's interesting. So then the last part, if you are aware of any evidence which tends to explain away the above crimes, and it is your desire that the evidence be presented to the grand jury, then you or your attorney must furnish such evidence to the office of the district attorney immediately. Responses to testify or present evidence can be addressed to it in the address. We don't know if he did that. From what I've read in the transcripts so far, he did not. And that could be, his counsel may not want to tip their hand to the grand juries. That would give the DA time to counter it in their argument once it goes to trial. I'm not sure. Be interesting to see. So there's one. Let's see. I don't remember what to RB. Let's see. Here's the recording. Super event, Reggie White, specific crime, murder with a weapon. Okay. Provided to, okay. Oh, it's the transcript. Okay. Again, it was during a police investigation, so I would think it would be recorded. I don't know how they figure it was not done properly. Oh, wait, what is this? When did this occur? Let's see. Murder with a weapon. Oh, this is Reggie White's statement. Let's see what Reggie White had to say in this statement. So it's a transcript of a recording conducted by the detectives' names, done on April 14th, 2022 at 14:30 hours. Okay, so this is where they start the recording with who they are, who's being interviewed, his description, his address, cell phone number, date and time of the interview. Present during the interview were Reggie White and the officers. Let me go through the pleasantries. Hi, how are you? Fine. Tells them who they are. The partner, I'd like to speak with Reggie. Reggie's bedridden. Interesting. He's what? Bedridden. Okay, let me talk to him. Okay, it's about Tupac. I'm trying to bring that case to a close. So I'd like to talk with him briefly about what he might know. I know that I've watched a lot of his YouTube videos. Let me just talk to him real fast. He's in bed. He's bedridden. He had COVID-19 back in December, and he hasn't been able to walk since. So, since December 2020, with COVID, he's been bedridden and unable to walk. That's scary. The officers, oh wow, I think I just said that. Let me talk to him, okay? The officers, he can't walk, but you can talk on the phone apparently. Let's go to page 2. Okay, pleasantries. All right. Oh, the person comes back. He's okay with it. Officer's perfect. Yep, thank you. Somebody says, I have a little dog. I'll put him up. Oh no, I'm fine. He's got a 120-pound Rottweiler. There's just them putting the dog up. He's in here, you guys. Can't really understand. Reggie, how are you? Good. Okay, here we are. How are you? Good. Kind of. My name's, and then bedridden. Let's see. From COVID. This is my partner, Jim Milligan. How are you doing? Good. Nice to meet you. More pleasantries. All right. So, the reason I'm here, I was handed the Tupac investigation. Okay. Oh, I guess maybe this was in person. They went and talked to Reggie. That's my guess since they put up the dog. I apologize. I misspoke. So then I was wondering if you might have a little bit of time to talk about what happened. He said, okay. Do you recall that night? Of course, I talk about it all the time on YouTube. Wright's not sure about the fact that he talks about it on YouTube. And the officers, I've seen your YouTube. Yeah. So in other words, the officers are increasing his viewers because they're watching the videos too. So, hey, law enforcement, watch mine, increase my viewers. I haven't committed any crimes though, but still you can watch it, increase my viewers. Last time you were something, it's not really, yeah. So he's clean shaven when they saw him last. A little bit, y'all need Keefe D number, got his number? Yeah, what's Keefe's number? Yeah, I'll give you his number. All right. Do you talk to him? Let me scroll here. I set him up with a couple interviews, and I promise you, if y'all ever listen, I promise him I would, You talk bad about each other, but you know me. I'll hook you up. I'm kind of know all these YouTubers out here. Oh, so Wright knows all the YouTubers out here. Mr. Wright, I'm a new YouTuber. Can we talk? I'd love to talk with you. Probably can't. I'm going to guess he's under subpoena for the trial and can't talk to me. But I will check out his YouTube channel, see if he said anything. We're going to have to do that in another stream. Okay, so I kind of hook people up with them. Want to make some money. So what do you get paid for interviews? About, let's see, 2,500 to 3,000 a show. Okay, Mr. Wright, I can't give you $3,000 to come talk to me, but if you want, we'd love to talk with you. All right, so 5,000. I got my he was crying about his taxes. I got him about to go blast him next week. He's getting like 3,500, so they pay you because they get views. They get paid, man. YouTube, every million views, you get about $6,000 to $7,000. I didn't know that. Wow, that's a decent paycheck. I am not monetized at this point, so that just amazed me. Wow. Okay. Anybody want to give me an interview? Because I'll darn sure do it for, $3,500. But back to Reggie's statement. Okay, I'm talking about the YouTuber. And so if you do a whole bunch of them and you get $100,000 and they break them up into like 5 or 10-minute segments, and you get, say, a 15-minute, you get, say, a 15 segments for me, and you get 200,000 people to view it, you can make between $8,000 and $10,000 off of me. And you just gave me $2,500 to $3,000. That's just astounding to me. Wow. Okay, if he's telling the truth, that's crazy. But okay, so Mr. Wright says he set up the interviews and gave a money breakdown that again, is astounding to me. But wow, let's go on to Exhibit C. What is Exhibit C? Defonte Lee. Okay, admits to being from the South Side, from Burris Crew, Friends, Baby Lane, Orlando, Keefe D, dope dealer. Okay. Sorry. So Keefe D is the dope dealer. Tremont Anderson, Crip Cave, Clicks, Burris Lane. I think these are somebody's notes. I don't know. Oh, and then a whole lot of redaction. Okay, let me stop that. I don't need to talk. Heard Orlando killed Tupac. Orlando never admitted to the shooting. Okay, more redaction. Knows of no SS who has a Cadillac. Orlando said he was going to sue Tupac and Suge. More redactions. Tupac. Maybe these are her notes. I don't know. Dre would not be driving too big. Orlando has the type of personality to shoot to get revenge. T. Brown would shoot. Does not think he shot. Lee asked him, said he didn't shoot. More redactions. Redact. All right. That was odd. What do we got in Exhibit D? Oh, all right. Let's look at the character references, shall we? Okay, so this is from a Bobby Joe Fox, who's a neighbor of Mr. Davis. He's lived next door to Duane and his family for 9 going on 10 years. We do live in a cul-de-sac. Most of the neighbors, did not redact his email address, folks. I'm going to have to go back and do that. But thankfully, I think I scrolled fast enough. We do live in a cul-de-sac, and most of the neighbors have been here quite a number of years. They enjoy sitting in the garage saying hello to everyone. If you go out on a walk or drive, you can always count on a friendly wave, hello, or conversation. Duane has a minor grandson who has grown up with the other children in the neighborhood. For holidays like the 4th of July, the street kind of does a block party, and you will see everyone out mingling, hanging to death. The block parties happen a lot around Henderson. I don't think they do so much within the Las Vegas city proper, but in Henderson, it's a growing community, but still very tight knit. Let's see, son. Okay, his son Keith is always out waving hello. Stops to ask if we need anything, offering any help. Mom is always busy cleaning and keeping things tidy. What's my point to all this, you might be asking yourself, is that before SWAT entered the Davis home, we knew nothing of any gang affiliation Duane may have had in his past. I believe what he says that is his past, that is it. That it is. Okay, sorry. Never have I seen anything to suggest otherwise on our street or in our neighborhood. We just knew and know him as our neighbor Duane. We never even heard the name Keefe until the name came out. They have been great neighbors since day one and moving in with zero problems. We truly hope you can see is of no threat. And then it's the neighbor. Well, all right, there we go. So what do you guys think? I'm torn, folks. I just don't know. Let's go back over. Let me find my mouse again. I will do the redaction of identifying info and post this up so y'all can read it at your leisure if you like. But again, let me know, why is my mouse not going where I need my mouse to go? All right, give me just a moment, folks. I'm trying to not show. Sorry. Didn't mean to do that either. Where is my mouse? There is my mouse, kind of. Okay, let's see. No. I apologize. I'm going to find my mouse. I'm going to find it, really. No. I need it over here. Okay, so I guess we're just going to... Oh, there we go. All right, we are back. Let me go look real quick on the court website and see if we have a reply from the state yet. I don't know if we do, but let's look and see. Let me move this. Let's move this where I need it to be. Okay, we'll look right here. That's fine. All right, let me look. Oh, I got to sign in first. All right, looking to see if we have anything from the state in this matter yet. Give me one moment. If y'all have any questions, feel free to ask, and I will do my best to answer them. Let's see why we looked this up. I should have looked again. I did look before I started the stream, and it is the Friday before Christmas. So I will admit I will be kind of surprised if they have filed anything yet, but let's look and see. Scroll, scroll, scroll. Nope, nothing yet since the second writ to extend the time for him to file his habeas corpus brief, which they have both sides, prosecution and defense, to Davis's pretrial writ of habeas corpus being filed by January 25th. All right, guys, I have to go finish my Christmas shopping. I am going to do curb pickup because I do not want to go into a mall. And then I have to bake cookies for all the grandchildren and children that are converging on my house on Sunday. Also got to watch that Chiefs game. To everybody who watched this first edition, I'll get better with time, I hope. Hope y'all will join me the next time after the holidays when we'll again go off the record. You guys have happy holidays and the great rest of your day.